Arbitration is actually a private court system that exists. In order to be subject to arbitration, an employee has to sign an arbitration agreement, and that would exist in the employee's personnel file likely. And you know that big stack of documents when you get hired, saying that you received the handbook, you fill out like a W-4. A lot of times arbitration agreements are hidden in those documents, and you agree basically when you sign an arbitration agreement, you are agreeing that if there's an employment dispute, that you will not sue in district court, whether it be federal district court or in our state court system. And instead, you have to go through a private arbitration process in order to assert your rights for, say, a wrongful termination case, a discrimination case, or a retaliation case. So instead of filing the case in court, you have to go through this private court system called arbitration, which is a lot like court. It's a similar process, but it's kind of under a veil of secrecy, so to speak. I don't like arbitration, and employees shouldn't like arbitration because they tend to have lower awards in arbitration. The arbitrator, or it's usually like a former judge or something like that, tend to give kind of lower awards and split the baby, and it's also not public, so the employer doesn't have a risk of bad publicity if they're arbitrating a case in the arbitration forums. Mediation is just where an employee is trying to settle their case through the services of a third-party neutral person, usually a judge or a former judge or a respected lawyer in the community. And on the one side, there'll be the company, and on the other side, there'll be a law firm like us, and we try to take a day to settle your case through the mediated third-party neutral process to come to an agreement to end the case.